Okay, I'm going to try to make this at least as interesting as Ken's part. I don't know about you guys, but I enjoyed that. I enjoyed Ken's part. So here we're going to talk about patentable subject matter. Once again, if you guys have any questions, feel free to ask. Stop me in the middle. Patentable subject matter is sort of like the doorway that everyone has to go through before a patent is even considered, right? You usually don't file a patent on something that can't be patented. The question is, what can be patented? And then only then afterwards you start asking the questions about, is it new? Is it an event that you start searching around? But the law, at least in the US, and I think it's more or less pretty similar in a lot of different countries, is written here. Whoever invents or discovers any new and useful process, machine, manufacture, and manufacture here refers to something that is manufactured, or composition of matter. And composition of matter means it could be a new compound, it could be a new formulation. You have a new pill that combines an active ingredient with other inactive ingredients. May obtain a patent therefore. So we have really four main categories of subject matter that can be patented. We're going to focus on these, and we're going to talk about what the exceptions are also to the rule. The law pretty much states a few things, at least in the U.S., and here too, it's pretty well accepted all over the world, that there are certain things that can't be patented, like a law of nature. Someone before mentioned Higgs particle. Just finding a particle would, or finding a law of nature, we refer to that as discovery, and not necessarily as an invention. Here the law talks about an abstract idea. We're going to talk about that more. What does that mean, an abstract idea? And natural phenomena. Here, similar to a law of nature, you find something naturally occurring. Find a new element. I'm not talking about synthesizing a new element, but finding something that's naturally occurring. This can't be patented. I think that one point that I want to stress that applies to, I guess, both parts of the presentation is patents are really a per country issue. In other words, if I want a patent in the U.S., I need to play according to the laws in the U.S. In Europe, according to the laws in Europe. In India, according to the laws in India. And there are going to be differences of law depending on the jurisdiction, depending on location. But there are processes in place to assist a patentee in obtaining a patent in a lot of different jurisdictions at the same time. In other words, you don't have to file this patent application simultaneously everywhere in the world. You have to start a process. From that date, you're protected everywhere in the world, provided that you continue along that process. It's very rare that a company will pursue worldwide protection in every single country, because that becomes very expensive. We didn't talk about costs here, but as anyone who's involved in patents knows, costs are sometimes the deciding factor as to whether patents should be filed or not. Back to patentable inventions. What are abstract ideas? Now, recently there's been a lot of discussion of this in the U.S., and I think that the U.S. has become a little bit even more strict about this concept of abstract ideas, because people were getting patents for business methods. I guess if you look at patents in the early 1900s, in the Industrial Revolution, you see a lot of people developing new machines, and you could say, okay, there's something solid, concrete here. That's the type of activity that was being focused on in terms of industry. And 100 years later, you get more into computing and methods of computing, methods of doing business. There's been criticism over the last few years about patents that had to do with a one-click buy. That you go into a website, you click, and one click is sufficient to put something in your virtual shopping cart and to purchase it. And that was a patent that was granted and was dealt with in courts, at least in the U.S. And I think that there's now sort of a switch saying, we have to really define what's abstract. And you're doing things in your head, and you're, let's say, comparing data. That's something that courts have found to be not patentable subject matter. It may be important, and this touches on, I guess, the biological sciences as well, because of diagnostics, right? Diagnostics essentially says, you may not necessarily, in certain parts of the process, you may not be doing anything, any material changes. You're taking a sample and you're learning something about it. So what's the invention here? I guess, obviously there are parts of the diagnostic field that can be patented. The actual tools that are used, sometimes the antibodies that are used can be patented, but the process itself, sort of an intellectual mental process. And another example that was thrown out by courts was a patent having to do with meal planning. And here what you're doing is, and the way the courts discussed this was, they addressed organizing human behavior, not necessarily invention, because it does not fall into one of the categories, the 4 categories mentioned, of patentable subject matter. Now, one question that came up, I think, as early as the 1970s, can a life form be patented? Because we had mentioned natural phenomena. That's something that can't be patented. But with the advancements in biological sciences, we can genetically engineer new life forms. So how does patent law address this? And we're going to talk a little bit about a case that was kind of controversial at the time, but it is sort of the backbone of the law in this field. General Electric. Now, you don't really think of General Electric as a company dealing with microorganisms, but at one point they did. And the problem was dealing with oil spills, in that oil spills generally have petroleum, a lot of different compounds that make up that petroleum, and they wanted to be able to digest it and somehow clean it up just using some sort of natural bacteria. So natural bacteria wouldn't work, but natural bacteria was able to do part of the process. So what they decided to do was, since there are a lot of different hydrocarbons and there are different organisms that can be used to digest different hydrocarbons, let's try to genetically engineer one bacteria that can degrade hydrocarbons using various different pathways. So it can tackle a big complicated problem. And by the way, this is something that was never became an important product, but patent-wise it was important because they came to the patent office and they said, look, we have a new organism. Nothing like this exists in the wild, because in the wild every single bacteria will only have one sort of plasmid, or one sort of degradation pathway that's focused on. Here they managed to take a bacteria, introduce at least two different degradation pathways for achieving this goal. They had novelty. Ken talked about novelty earlier. They had potentially something that was new and that wasn't obvious to do. What happened when they got into the patent office? The patent office says, this is a life form. You're claiming, and we talked about claims being the end of the patent. One of the claims in this patent was a claim to a life form, right? To the bacteria, the claim that we saw. Let's just go back to it. A bacterium from the genus Pseudomonas, containing therein at least 2 stable energy-generating plasmids, each of said plasmids providing a separate hydrocarbon degradative pathway. So that was the claim. That's what they're trying to protect. They're trying to protect a life form and actually get a patent on that life form. They're essentially one of the first ones. Patent office says, no, sorry, this is not patentable subject matter, right? Doesn't fit into these categories that the law allows. To make a long story short, because before getting to the Supreme Court, it has to go through various other courts, and there are very few patent cases that are actually heard at the Supreme Court on the highest level, but they have to be something that's very precedential, as this case was, known as Diamond versus Chakrabarty. Diamond being the at the time the head of the U.S. Patent Office, and Chakrabarty being the inventor for General Electric. This is going back already to 1980 that the Supreme Court heard this, and the Supreme Court said as follows: if you look at the law was written way before people thought of patenting genetically engineered life forms. But the law was written in an inclusive way because it uses language as "and the like." So talk about a process, manufacture, and the like. You know, the law is open. The law intends, the lawmakers intended anything that's really useful and that can be compared to one of these categories to be patentable. What do they mean? Anything that's man-made. When you say that a naturally occurring organism can't be patented, that's not because it's alive, but it's because it's a product of nature and it's not man-made. We're not going to reward someone with a patent if he just discovers something that was already naturally occurring. However, this claim referred to a bacteria that was not naturally occurring. It had to be made by this inventor, and subsequently this patent was granted. And this paved the way for patents in the biotech field, relating not only to this specific field that we discussed, but to the fields of pharmaceuticals, which I think is probably one of the fields that patenting is most focused on, biologicals and organisms, and agriculture as well. Let's just see who are the parties involved in this. It's interesting in the case of Diamond versus Chakrabarty that we have the patent office on one hand saying, you know, this is the way we've constantly been doing things, not patenting life forms, and you have the inventor on the other hand and the patentee wanting to push this forward. Now let's get to the next question about DNA. Can DNA be patented? And I think Eddie touched on this question earlier. So we know DNA is naturally occurring, right? We know, but at the same time we know that there are patents that relate to DNA. So one of the tricks that patent attorneys have been doing for many years, probably since the 1980s, is saying, look, Diamond versus Chakrabarty taught us something important, that naturally occurring things can't be patented. However, even life forms can be patented. So certainly DNA can be patented. If it's naturally occurring and we take it out of its source, and it's no longer in that same cell that it was in when it was naturally occurring, or maybe we isolate it, okay? And that is considered a human activity. We have contributed a human activity, and now we make this something that's patentable. So if I name a sequence and I call it isolated, I can patent it. And that was what was happening since the 1980s. Until we get to a case about Myriad Genetics. Many of you may be familiar with this company, Myriad Genetics, which started as a small company, but built up to a rather large company that dealt with genetic testing. And as we know, there are certain genes which people have that give them dispositions to various diseases, in particular cancer. And we know about the BRCA gene. And Myriad had a patent, essentially, on the BRCA gene, and performed diagnostics to say who had this gene, and essentially medical decisions would be determined based on, you know, options for treatment of cancer or prevention of cancer would be taken based on this testing of patients, whether they have the BRCA gene or not. So here's a mutation. Happens to be rather common among certain populations in the Jewish people. They have claims, some of the claims of their patents were to isolated DNA for these genes. And this company went ahead, and a U.S. company, and built up this technology And these tests would cost sometimes up to $2,000 per patient. So you can see that there's a life-saving test, and it costs a lot of money. There's a lot of technology involved, and they've had patents that protect them and allowed no one else to perform these tests. So all of a sudden, some various organizations got together and challenged these patents. And here the patents have to go through first the district court, then the federal circuit, which is essentially the court of appeals after the first patent court, and then it was heard by the Supreme Court. And who was against these patents? We have a bunch of people together. We have patient advocacy groups who were interested in lowering the cost, and they're very anti-patent. Now, when we talk Ken's presentation about what the patent system is, people will get up and say, hey, you guys, you're taking advantage of the patients because you're charging $2,000 per patient. You're making a ton of money off of this process, and the patients are suffering. The flip side of the coin is twofold. First of all, this company did a lot of research, invested a lot of time to get this. If they would not have been able to return this investment, they would not have invested the time to begin with to develop this test. So no patient would have this test. Secondly, this patent protection is for a limited amount of time. It's only for 20 years. After 20 years, everyone else has free ability to practice it. Not only that, like Ken said, the patent gives the people the directions of how to do it. I read the Myriad patent. I know that this is something that I can do. I can read their patents, understand what I can do, what they do, and then I can compete with Myriad because the patent protection is up. So the patent system makes sense, but at the same time you have these patient advocacy groups saying, look, we have these patients, they can't afford the testing, it's life-saving. The ACLU, the Civil Liberty Union, which is interested in rights of the individual. And they said, you guys are patenting genes, okay? My genes are mine. I don't want anyone to control my genes, okay? And this is a little bit of a complicated argument because what they were claiming is isolated genes. I'm not claiming genes in anyone's body. I'm claiming genes isolated outside of the body, outside of that cell. And researchers also joined suit because they said this shouldn't be protected. Now here the Supreme Court came down with an interesting decision. They say, nor do we consider the patentability of DNA in which the order of the naturally occurring nucleotides has been altered. In other words, if altered genes have been changed, that's not what we're talking about now. Scientific alteration of the genetic code presents a different inquiry. And we express no opinion about the application of 101 to such endeavors. 101, by the way, is a section of the law which deals with patentable subject matter, which is what we're discussing. We merely hold that genes and the information they encode are not patent eligible under 101 simply because they have been isolated from the surrounding genetic material. So DNA, genes that are isolated, Supreme Court comes along and says you cannot patent them just by adding the word isolated, okay? Modify them, okay, that's a different story. But isolating them, if they're the same as the naturally occurring genes, and all you do is you take them out and you call it isolated, that cannot be patented. And here we have hundreds, if not thousands, of patents that were limited because of this decision, because that was standard operating procedure from the 80s, that if there would be a new tool, diagnostic tool, or method, treatment, there would be claims to isolated genes. Eddie?
Yeah, what about regulating them? Because now you have a lot of technologies that are based on gene silencing, for example, where you're not really modifying the gene, but you're regulating whether it's going to be overproduced or underproduced or silenced.
Once again, you hit the nail on the head. And I'm going to address that right now. The ramifications of this decision in the Supreme Court, which is from not so long ago, 2 or 3 years ago, that a lot of patents are called into question. But what it requires us to do is to carefully draft process and product patents going on. As we know, as we said, you can protect products and also processes, new methods. So if we were to redefine what's happening here, a different stage of the process, not necessarily claiming the gene, claiming altering the gene, various ways of expressing the gene, methods of treatment, using an agent. And in fact, I just recently got a patent allowed that it refers to genes, but the way it refers to genes is a method of treatment of a specific disease comprising upregulating this gene. Okay, and that's fine. Myriad, this decision does not talk about that. I'm not claiming the gene. I'm claiming a process, and here in this patent also that I'm talking about that was allowed by the examiner, or soon to be allowed by the examiner, is not only the discussion of which genes are going to be upregulated, but how to upregulate them in a specific way. So I think does that answer your question?
Yeah, more or less, but let's say, for example, technology of RNA silencing.
Mm-hmm.
I mean, it's a known technology. So if I put that together with a gene, the question is it still novel to say I'm regulating this gene to increase the yield in tomatoes, for example?
Well, I think it really depends on what was known about that gene, and one way to tackle this is, what specific sites are you targeting through the RNAi, and that's the way we did in this case I'm talking about, that we just got an allowance for. We said, this is very very specific site of this gene. This is a site, and this is the activity that we're preventing, and this is the activity that we're enhancing. Okay, but it has to be very case specific about what's known. You're right. In many cases, this sort of patent, if the gene is known and its function is known, then a method like this, method claim, would also not be allowed. Okay, but once again, case specific. Now let's go look a little bit about agricultural technology. I think we can divide it really into two different parts, what we call plant breeders' rights and utility patents. In the U.S., plant breeders' rights are known as plant patents, whereas in most countries in the world it's not, and it's known as plant breeders' rights, and it's something different. Here, for example, here in Israel, this is plant breeders' rights exist, and they're not regulated through the patent office, but through the Myriad Genetics, through the agricultural ministry. Thanks. But there's also patents. Here, plant breeders' rights, essentially, what do? They give the organizations that, including Volcani, they give them exclusivity also for 20 years on a new plant that's been characterized. It has to be clearly characterized, and how the plant is different from what was known previously. Not my specialty and not our topic of today, but we're going to talk about patents that are, I guess, broader, because they're available for a lot more different types of technology. What types of technology? Now, we clearly have machinery, including farm equipment and irrigation equipment, greenhouses. Processes can be protected, whether it's processes for growing, for water treatment. I think we have a client that has new technology relating to greenhouses, as well as we have some clients that are active with methods of growing fish. Now we get to the topic that we recently discussed, which is genetically...
Robots, yeah.
Robots, okay, exactly.
With Volcani.
Yes. Genetically modified organisms. We just set down the case law, both Diamond versus Chakrabarty and Myriad, which say that genetically modified organisms can be patented, even though it's a life form. At least in the U.S., it's the same way in Europe and in Israel. Biological control, there are patents for this as well. And compounds, I guess, probably one of the oldest ways of protecting it is through simple compound protection of a new fertilizer, new combination of fertilizers, pesticides, and a lot of companies are active in this regard. What I did here was I looked at international patent applications that were published by 8 companies that were from a list that I was given by Eddie that all have presence here in Israel, that are agritech companies. Oh, that's better. Okay. And we see this doesn't indicate the patenting activity of all these companies, but we see really 4 big players here. We see Gene, and we brought an example of their sort of patents before. A lot of their patents are very similar, and we'll deal with that same sort of structure, and what will be different is the sequence, okay? I guess sort of a template for a patent. By the way, that patent that we showed you in one of the earlier slides, we showed you the first page and one of the last pages, but there are some 240 pages in between. So just to give you an idea about what sort of documents have to be both prepared by patent attorneys sometimes and also examined by patent examiners. You have to actually read through that, or at least read through most of it. A lot of times that will include many inventions in it, and what's filed as a patent application won't all be accepted as one invention at the end of the day. We have Israel Chemicals dealing with various chemical solutions, and Nitafim, their patents relate mainly to irrigation, and Mikorot, water treatment. Here, this is not an inclusive list. This is specific years, and these are only PCT applications, which is the international route for filing patents worldwide. It could be that there are other companies that didn't use this route that filed only national applications, and that wouldn't show up here on this. Now we're reached the end of the presentation, so if anyone has any questions.
So one of the things that many of the people here are working on is biological control organisms, where because of obvious reasons, so for example, especially European requirements, there's a very feeling for genetically modified organisms. So generally when you use these organisms, they won't be genetic, so they'll be natural organisms. But then the question is, I don't know if you can think as far as use patents, you can still take out a patent on using a certain organism for treating a certain disease or for causing plants to grow better or for reducing fertilizer use or something like that. So if you can say something about
Okay. Use patents is, what we, in one of the slides here, we talked about what is patentable subject matter, okay? This one, the first one in my presentation. Process, a useful process, okay? Process is what Eddie is talking about. In other words, we're not going to patent the organism that's naturally occurring, but we can patent a process. Now, let's talk about the infringer. Who is infringing this patent? Who is violating my right once I get a patent that says a process for using this organism for treating this disease of a plant, okay? Let's say. Organism A for treating disease B on plant C. Who is violating that? Now, literally, if I am a provider of this organism and I'm not the patentee, am I practicing this invention? Am I actually going to the field and using this organism? No, I'm not. Right? What am I doing? I'm giving this organism or selling this organism to a farmer, and the farmer is doing it. Okay? But as a patentee, the farmer is my customer as well. In other words, there are hundreds of thousands of farmers worldwide. They are my customers. I have to provide them with either my product or my competitors will provide them. I want to stop my competitors. I don't want to stop the farmers right? And also there's so many of them, I'm not going to sue all of them. So what am I going to do? I want to make sure that I can stop my competitor. But we said, wait, my competitor isn't infringing. So what we want to do is we want to get a patent that protects something else, what's called inducement of infringement. In other words, my competitor, he is not infringing, but he's inducing someone, he's telling someone how to infringe. Why? Because he sells a product, right, a life form, and he writes on his labeling of the life form, he says, we're selling this to be used in X, Y, Z, okay? Or not, right? If he's doing this, then he is inducing infringement. In other words, what I want to do as a patent attorney to protect my client, I want to make sure that my client, his labeling, the way he packages his product, is covered in the patent. In other words, the labeling is what tells, is the way the company tells the user how to use it. That can be inducing infringement if he does not have patent rights. And that's the way I want to make sure that my labeling matches, as a patent attorney, I want to make sure that my client's labeling matches his patent. Because we're assuming that the competitor is going to want to not only copy the product, he's going to want to copy the labeling as well. Now, I don't know this field well enough to say if, bottom line, that happens. I can say that in the pharmaceutical field, we know that a generic competitor, when he goes on the market, his labeling has to be the same as the innovator company. Are you guys familiar with the innovator generic concept? A lot of companies are innovators. Those that make those same products after patent are called the generic companies. So the generic companies are required by law to have the same active ingredient in the same amount for the same use with the same labeling, or more or less the same labeling. So here, the way to protect your new use would be through, like Eddie is saying, through a use patent, and also making sure that your use patent covers your labeling and hopefully also your competitor's labeling, because he's going to want to address the same exact market that you are addressing. And I guess the more regulated the market is, the better the stronger the patent can be, because in a non-regulated market, you don't need to sell a product with specific labeling, right? I can write, I'm selling it for a different use, and therefore I'm not infringing your patent if it's a process patent. I'm not inducing infringement because I'm selling it for something else, right? Because if my patent and my labeling say organism A for use treatment of disease B in plant C, and someone else sells it for something else, I can't stop it. So here we have to understand the regulatory atmosphere, and that's how we can properly draft patents that will cover not necessarily the product, but the process of using the product, and thereby prevent competition.
Just to add a comment on this, in the crop protection law, you mentioned, it is in principle required to copy the originator, but in the U.S. specifically, you're not required to submit in any data. So you could basically write a new label if you want to, but the claim is on you. So a farmer can sue you, and it's up to you, to the supplier, to defend yourself.
So what you're saying is that
in principle, you're obliged to copy the original label. Since you're not required to submit any data to support that, if you're creative enough, you could write your own label, but then you're risking being sued.
right.
I would say writing the use is the most important thing. Because once the product is on the market, you can check what's in there. So if it's, you don't really have to have all the ingredients and etc. Just the use of the product. Then you can check it. You can buy it, you can see what's in there, and if it's using infringement.
Right.
So
I mean,
there are very specific requirements on labeling. You can't write just whatever you want. You have to follow a very
You
clear
have to
guidelines.
follow, but if it's not written exactly as infringed patent, you can still check what's in there.
You have to. There's no question. You have to mention what's the actual ingredient. You have to mention how to use it. There's basic performance. There's no overcoming.
So what you're saying is if you have a product with an organism, you say it's for soil protection, and somebody else markets it as a soil enhancer, and you didn't have that claim, then basically they're not infringing.
Right. Even if it's the same organism. Yeah. So your claims really have to focus on what it does, what you expect it to do, and what you expect infringers to do with it as well.
How strong are these induced use claims?
They're pretty strong, at least in the pharmaceutical field. They're pretty strong because, like I said, because very regulated.
You still go after a supplier with this claim with a relatively good.
Well, I'll give you an example. There's a famous drug that a lot of people know about that's on the market that did not have a compound patent on it at all. And the only way it was protected was through a use patent. It is known as Viagra. And the Viagra patent was allowed in a lot of countries, and that was what was preventing competitors to get on the market because it said exactly what it was used for, and that was the labeling. So no one else could get on the market because the regulatory and the patent system were intertwined. There's one exception to that rule, which is India, which Pfizer had filed for a patent in India, and in India they said, here we talk about patentable subject matter as a process, right? And that includes in the U.S. it includes methods of treatment. In India that's not allowed. There's no way to cover a known product for treatment of a new disease, right? This product was sort of discovered. It was originally developed for cardiovascular indication, and the clinical trials failed, but then it was later developed for erectile dysfunction, ED, and that was what it was marketed for. So the only way that most countries it was able to be patented was through use patent, and that was a patent that kept the very strong protection until the patent expired. Except, like I said, this exception to the rule, which has a little bit of a different patent. I guess.
I have one more question.
Sure.
What about combination patents? I mean, let's say, for example, combining a number of different organisms into a product.
Mm-hmm.
So A, with the combination, could you claim that these organisms wouldn't generally be found together, so therefore you're taking them out of the natural context?
I think that, well, you generally have a problem with combinations. And the problem is as follows. We discussed obviousness. So if we know A is, organism A is effective in treating a certain plant disease, and organism B is also effective, and you guys come along and say, hey, guess what? When you put A and B together, it's also effective. The patent office will turn around and say, thanks, but this is not patentable, because this is a classic example of a combination of two teachings, and that's obvious, okay? However, how do you overcome that? Now, you guys know. Okay, now, check this out. Here, we have some spare slides in case people ask good questions that weren't on the schedule. Here, how do you respond to an obviousness rejection? So we have surprising advantages of the invention. Surprising, and synergy is a surprising advantage of the invention, okay? That's one way, that's one big way. We talk about synergy all the time. You guys know it, you guys know about it. A and B together, rather than having an additive effect, have a synergistic effect, okay? Where 1 plus 1 does not equal 2, but it equals 10, or even equals 5. You have what's called synergy. These work really well. You can lower the amount of what you're administering. Here we have two different examples. Another way to overcome it is to say, look, we went into the market with this product. This product has A and B together. And for some reason, we got awards for it. And our sales have increased by a factor of 10 because of this product. That's enough to go back to the examiner and say, look, if it were so obvious, then everyone would have done it. But this shows, what we call secondary considerations, show that it was not so obvious. So these are ways to overcome problems of combinations. Sometimes combinations, A and B will not be known for that specific disease, and you'll be the first one to put them together. It could be A was known for one disease and B was known for a different disease, and you put them together on a third disease. So that's and then they had that effect, and then you wouldn't be facing the same exact fact pattern, same exact obviousness situation. So every question about patentability has to really be judged on an individual basis. But there are definitely patents for combinations, and something to consider.
Secondary consideration is still a viable argument in the U.S.?
Yes, indeed.
Absolutely. I've gotten a couple of allowances recently relying almost completely on, like industry awards and other third-party experts saying, "Wow, this is amazing." Like like from like articles and websites for the awards and press releases for these people, and it works.
I recently sent a YouTube video to the examiner, a link to the YouTube video saying, "Look, this is what customers say about the system," and you have a customer testimony. I didn't have it prepared. It was prepared already before the office action.
The reactions in the...
Yeah, so it was an indication of secondary considerations. The fact that customers are very happy with it, that already shows that it's not obvious.
Can I ask a question?
Sure.
This is talking in late, and I apologize if you spoke about this. Is there could you make a comment on the differences between the various international bodies, like the U.S. versus Europe, in the style of evaluation? I know, my experience is very different.
There are differences, and I think it also depends on the field. One of the major differences, I think we touched upon a little bit before, is that the U.S. allows a grace period. Even there was a change in the law. It used to be there were a lot more differences, and then there was what's called America Invents Act 2013 that changed a lot of the way the U.S. law worked and sort of harmonized it with the rest of the world. So it used to be that in the U.S., if you were only focused on the U.S., you didn't have to rush to the patent office to file something. You could be the second person to invent, and you could still be, and you could be the first person to invent, but the second person to get to the patent office. And if you could prove that you were the first person to invent, you would be able to get the patent, even though someone else came and patented it before you.
This is the problem with the CRISPR method.
Okay, yeah.
There's a lot of becoming a big news lately.
Yeah. In terms of now current differences, one of the big differences that we did touch upon is the grace period. In the U.S., if you discuss something, and this is what Steve Jobs did, because he discussed something when he released the iPhone, and it wasn't yet patented. So in the U.S., he can get a patent on that, but in Europe, he was not able to. That's one of the big differences. I think that there's a lot more unification, whether it's consciously or subconsciously. Methods of treatment. Okay. This is something that's a little bit technical, but the U.S. allows you to claim a method for treatment of a disease using compound X. Whereas in other countries they say, no, that is something that's preventing a doctor from giving a treatment, the way it's written. So what they do is they make him word it a little bit differently. Okay? that the goal of the rewording is in order to focus more on the manufacture of it, not of the actual treatment. Bottom line is, in Europe and in the U.S., you can still get same sort of patents that will cover use of a compound, a second medical use for treating a disease, even if the compound was previously known, if the use was not known. Like I said before, India is an exception to that rule. So you have different systems that originated at different times, and it looks to me that there's a lot of moving towards the same goal. One of the other areas of difference is computer-related inventions. That's where you know, some countries are more strict if that's patentable, some countries are less. All right, thanks a lot. It was a pleasure being here. I'm glad you took the time.